and facilitated naturalization of refugees and stateless persons. I would like to acknowledge the following guests who are able to join us physically and virtually. The Honorable Chief Justice Alexander G. Gasmundo, the Associate Justices, Senior Associate Justice Estela M. Perlas Bernabe, Justice Mario Victor F. Leon, Justice Alfredo Benjamin S. Cagiwa, Justice Ramon Paul L. Hernando, Justice Henry Jean Paul B. Inting, Justice Rodil V. Zalameda, Justice Mario V. Lopez, Justice Samuel H. Gerland, Justice Ricardo R. Rosario, Justice Josep Y. Lopez, Justice Japar B. Dimaampao, Justice Jose Maidas P. Marquez, and Justice Antonio T. Co. Retired Chief Justice Diosdado M. Peralta. From the Philippine Judicial Academy, Chancellor Rosemary D. Carandang, Vice Chancellor Mariano del Castillo, the presiding justices of the appellate courts, Presiding Justice Remedios Salazar Fernando from the Court of Appeals, Presiding Justice Amparo Cabotaje Tang from the Sandigan Bayan, Presiding Justice Roman G. Del Rosario from the Court of Tax Appeals, the executive judges of regional trial courts in the National Capital Judicial Region, representatives
Recording in
from other
progress.
national government agencies, Chief State Counsel George O. Ortha II, Department of Justice, Commissioner Jaime H. Morente, Bureau of Immigration, Executive Director Maria Lourdes Fugoso Alcain, Council for the Welfare of Children, Executive Director Emerito L. Rojas, National Council on Disability Affairs, Development Partners from the United Nations, Mr. Gustavo Gonzalez, Resident Coordinator, Attorney Maria Hermina Valdiavilla Gallardo, Head of the Philippines Office of the United Nations High Commissioner for Refugees, non-governmental organizations, President Gwendolyn Pimentel Gana, Association of Child Caring Agencies of the Philippines, Executive Director Stephen Muncy, Community and Family Services International, Executive Director Ray Paulo Santiago, Ateneo Human Rights Center, Attorney Peter Joey B. Usita, San Beda University Legal Aid Bureau, members of the media, with special mention to the Justice and Court Reporters Association, or JUCRA, and the Justice Reporter Organization, or JURO, other judiciary officials and employees who are virtually present. Ladies and gentlemen, please rise for the ecumenical prayer, singing of the national anthem and the Supreme Court hymn.
Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
Mga kababayan, ang pambansang awit ng Pilipinas.
Kayang magiliw, telas ng sinakalan, alam ng puso, sa titik mo'y buhay. Lupang hinirang, tuyang ka ng magiting, sa manlulupin, di ka pasisigil, sa nagagang tutok sa simoy at sa langit kong pagaw, ay hinagang tulakaw.
you be seated?
When the crisis rate all my dreams has been destroyed.
Yo nunca pensé salir de mi país. Nunca.
Ile yote ilituogopesha sana na mpaka hivi tulikimbia mikono wazi.
War, violence, and persecution continue to displace millions of people across the world. As a refugee from Syria, I know the pain of being forced to flee your home and the difficult road to safety. Thanks to the Refugee Convention, my family and I were able to settle and rebuild our lives in peace. Since 1951, it has been the legal foundation for refugee rights and has saved countless people driven from their homes. UNHCR, the UN Refugee Agency, has been the guardian of the convention since the start and continues to ensure international protection for uprooted people. After 70 years, the convention is as relevant as ever. It gives guidance to states on how to protect refugees and calls for international cooperation and support in managing displacement. It has been signed by 149 states, and I hope more will join them soon. With record numbers of displaced people crossing borders, rivers, deserts, mountains and seas to find safety, it's more important than ever that the convention is upheld globally. Without the convention, I would not have the freedoms and stability that I enjoy today. I and millions of others would not have the opportunity to rebuild, to get an education, or to find peace, happiness, and hope. The convention may be just written words, but to refugees everywhere, it embodies an ideal. It allows us all to dream that one day, all those who have been forced to flee will be able to find a place to call home.
My name is Kamran Karbasi.
My name Mr. Maher Muhammad Al-Rai.
I left Iran 1987 after revolution. I came to Philippines. What I did, arrival to Aquino International Airport, I go directly to United Nations. I surrender myself there.
Basta arrive dito, bigay ko na babel ko, Palestinian ako. Ugaw ako refugee. Slowly ako, ibon gawa business. Gusto ko anak ko maganda buhay nila. Iwan sa kanila business nila. Mayroon sila lupa, mayroon sila bahay. Wala sila problema sa buhay nila.
I don't have any too much expectation. I just want to support my family. That's it. That's it. I just want to have a good future for my children.
The naturalization process can be either judicial or administrative. Since these are refugees who came from other countries, they will have to apply in courts. The case of Kamran was quite difficult for him. Now, the Supreme Court decided in favor of Karbasi. The Supreme Court said that in the case of Karbasi, under his present circumstances, it is unlikely that he will become a public charge in the future. So it was future looking how the Supreme Court resolved that. And mind you, under our system of laws, the decisions of the Supreme Court is part of the law of the land. Maher, the same. We presented the evidence showing that he was duly recognized as a refugee. But the case of Maher did not involve any appeal. So it went through the process smoothly.
Siyempre, happy na ako. happy, basta lalo, taking, iyak ako.
Now I'm officially Filipino. I really enjoy it. I feel free. I feel I am no more.
Good morning. Welcome to the media launch of the Rule on Facilitated Naturalization of Refugees and Stateless Persons. I am Laura Cruz Herrera del Rosario, Deputy Clerk of Court and Judicial Reform Program Administrator from the Supreme Court Program Management Office, and I will be your host for this event. We are also streaming live via YouTube through the Supreme Court YouTube channel. We are here today to inform the general public through the media about the Rule on Facilitated Naturalization of Refugees and Stateless Persons. The rule aims to simplify and reduce legal and procedural hurdles in obtaining Philippine citizenship to facilitate the assimilation and naturalization of refugees and stateless persons into Philippine society. It governs the procedure for the filing of petitions for naturalization by refugees and stateless persons recognized by the Philippine government. And now, to formally welcome the participants, may I present to you the Honorable Alexander G. Gesmundo, Chief Justice of the Philippines.
Please be seated. Senior Associate Justice Stella M. Perlas Bernabe, and colleagues in the Supreme Court, former Chief Justice Diosdado Peralta, Philippine Judicial Academy Chancellor Rosemary Carandang, and Vice Chancellor Mariano del Castillo, presiding justices of the appellate courts, Remedios Salazar Fernando, Amparo Cabotaje Tang, and Roman del Rosario, fellow judges of the trial courts, Commission on Human Rights Chairperson Tanodra Armamento, Department of Social Welfare and Development Undersecretary Adonis T. Sulit, Chief State Counsel George O. Orta II, Bureau of Immigration Commissioner Jaime H. Morente, Council for the Welfare of Children Executive Director Maria Lourdes Pugoso Alcain, National Council on Disability Affairs Executive Director Emerito El Rojas, our development partners from the United Nations Resident Coordinator in the Philippines, Mr. Gustavo Gonzalez, Head of the Philippine Office of the United Nations High Commissioner for Refugees, Attorney Maria Ermina Valdevilla Gallardo, Association of Child Caring Agencies of the Philippines, President Gwendolyn Pimentel Gana, Community and Family Services International Executive Director Stephen Mansy, Ateneo Human Rights Center Executive Director Attorney Ray Paulo Santiago, San Beda University Legal Aid Bureau Attorney Peter Joey B. Osita, members of the media, special mention to the Justice and Court Reporters Association, JUCRA, and Justice Reporter Organization, or JURO, other employees and officials who are present virtually. Distinguished guests, ladies and gentlemen, a pleasant morning to all of you. As the world watched the development of war in the Baltic region, it lay witness to the humanitarian crisis that followed. On our television screens, we saw millions of people flee from their homeland, while millions still remain internally displaced. Virtually, we followed them, the elderly, men and women, children, some unaccompanied, walking in mass exodus as they attempt to seek refuge from the conflict and cross borders to a life of relative safety but uncertainty. For the Philippines, the scene may be familiar. To a certain degree, Filipinos had experienced being uprooted from their homes because of armed hostilities and natural calamities. In present times, a search for a better life had triggered Filipino diaspora. In this, we share a common aspiration with all those fleeing from their home countries. An empathy towards those uprooted from their homes and an understanding of their hardships developed naturally among Filipinos. From these qualities, the Philippines shaped its policies and developed a tradition of providing a safe haven to refugees and stateless persons. Since 1923, Jews, White Russians, Chinese immigrants, and Vietnamese boat people all found a welcome transit point on our shores and sanctuary on our islands. From an executive policy of neutrality and openness, this tradition became embedded in Philippine laws until it evolved into an obligation under international conventions. As the Philippines acceded to the 1951 Convention relating to the status of refugees, its 1967 Protocol, the 1954 Convention relating to the status of stateless persons, and the 1961 Convention on Reduction of Statelessness, it committed to facilitate the assimilation and naturalization of refugees and stateless persons. Today, the Philippines has gone beyond giving shelter to these persons forcibly displaced by war, conflict, violence, and persecution. It now offers them full integration through citizenship for access to rights and social services. The rule on facilitated naturalization of refugees and stateless persons, Administrative Matter number 21-07-22-SC, is the judiciary's contribution to the country's fulfillment of its international obligations. It was created by the Special Committee on the Facilitated Naturalization of Refugees and Stateless Individuals, which was chaired initially by then Chief Justice Diosdado M. Peralta and now by Associate Justice Ramon Paul Hernandez. As Chief Justice, I committed to pursue the promulgation of this rule during a courtesical meeting by Gustavo Gonzalez, United Nations Resident Coordinator in the Philippines, and Attorney Maria Hermina Valdevilla Gallardo, Head of the National Office, UN High Commissioner for Refugees, on July 1, 2021. Within 8 months, the commitment was honored when the Supreme Court and Banc approved this rule. The only judiciary-led initiative of its kind at the global level. This rule was developed pursuant to the 2017 Interagency Agreement on the Protection of Asylum Seekers, Refugees, and Stateless Persons in the Philippines. The rule provides an expeditious and inexpensive procedure for the acquisition of Philippine citizenship by refugees and stateless persons. This is consistent with the aim to streamline court processes to ensure an efficient, fair, and speedy delivery of justice. Certain provisions are unique to this rule. For one, it allows for electronic publication of the petition for naturalization of refugees and stateless persons. For another, it allows relevant national or local government agencies to file a petition for naturalization on behalf of an unaccompanied child in recognition that displaced children are the most vulnerable. With this, children, especially those abandoned or separated from their families, would not be denied of the right to belong to and be nurtured by a homeland. Indeed, more than a procedural tool, the rule is a lifeline for refugees and stateless individuals. With the rule in full force and effect, they will gain a new lease in life, no longer segregated, uncertain, and helpless, but fully integrated, settled, protected, and most of all, accorded respect as human beings. I welcome you all to today's occasion. Thank you very much.
Thank you, Chief Justice Gesmundo. It is worth mentioning that when then Chief Justice Diosdado M. Peralta created the Special Committee on the Facilitated Naturalization of Refugees and Stateless Individuals through Memorandum Order Number 87-2020 on December 14, 2020, Chief Justice Gesmundo, who was then an Associate Justice, was designated Vice Chairperson of the committee. I wish to acknowledge the members of the Committee on the Rule on Facilitated Naturalization for Administrative Matter Number 21-07-22-SC. Chairperson, Justice Ramon Paul L. Hernando. Vice Chairperson, Justice Josep Y. Lopez. Members, Justice Jose Maidas P. Marquez, Judge Maria Josefina G. San Juan Torres, RTC Branch 79, Morong, Rizal. Dean Sedfrey M. Candelaria, Chief of Research, Publications, and Linkages, Philippine Judicial Academy. Attorney Nash Mylene A. Marohom Salik. Attorney Jeffrey G. Gallardo. Attorney Camille Sue May T. Ting. Attorney Maria Melissa R. Dimson Bautista. Attorney Walesa J. Mercurio from the Public Attorney's Office. Attorney Melvin C. Suarez, Department of Justice, Refugees and Stateless Persons Protection Unit. Attorney Dexter G. Matias from the Office of the Solicitor General. Attorney Alexander E. Bacaro from the Community and Family Services International. And now, the hardworking Secretariat. Attorney Helene Rashida L. Penilla. Attorney Justin Adriel Espaldon Ordoyo. Attorney Christine Lay G. Domingo. And Ms. Ariel N. M. Gonzalez from the United Nations High Commissioner for Refugees. To deliver his key message and the salient features of this new rule, I am honored to present the chairperson of the committee, Associate Justice Ramon Paul L. Hernandez.
Thank you. Good morning. The Honorable Alexander Gesmundo, Chief Justice of the Philippines, my colleagues, Justice Henry Jean Paul Inting, Justice Joseph Y. Lopez, Justice Pipar de Mampao, and Justice Antonio Ko, our Field Chancellor, former Justice Rosemary Taranda. The Chief Justice has acknowledged practically everyone. So if I may just be permitted to speak, acknowledging our key guests and visitors again, who just came in. Well, Justice Ben Kadiwa just came in. Justice Ben. Good morning to everyone. I welcome you to the media launch of the rule on facilitated naturalization of refugees and stateless persons. As chairperson of the special committee that was tasked to complete the drafting of the rules, I am very pleased that you are all here today as I introduce and present its salient features. They will be flashed across the monitors. The development of the rule began back in 2018 through the efforts of the Access to Justice cluster of the Interagency Steering Committee for the Protection of Refugees, Asylum Seekers, and Stateless Persons in the Philippines. Its members, which comprise of representatives from various government agencies, came up with the first draft of the rules. In recognition of the challenges faced by refugees and stateless persons in complying with the regular naturalization process, and as a result of the conduct of a focus group discussion held in 2019 involving Court of Appeals justices and regional trial court judges from select regions, wherein the creation of a rule on facilitated naturalization was recommended. Not long after, the special committee, which was initially chaired by then Chief Justice Diosdado M. Peralta, was formed and tasked to further enhance the rule. Upon Justice Peralta's retirement, the task was entrusted to me, and it became my duty to see to it that the rule would be completed. Chief Justice Gesmundo and myself also met with Mr. Gustavo Gonzalez, the UN Philippines Resident Coordinator, and Attorney Maria Hermina Valdea Villa Gallardo, UNHCR Philippines Head of Office National Office last July 1, 2021, where we made the commitment to pursue the promulgation of the rule. Thankfully, last February, with the smooth guidance of the Chief Justice, the Court and Banc approved the rule after it went through thorough revisions based on the comments, suggestions, and observations of my colleagues, particularly Justice Henry Jean Paul Inting and Justice Rodil Zalameda, and of course, Senior Associate Justice Estela Perlas Bernadette. The promulgation of this rule is a special occasion as it shows the Supreme Court taking a proactive stance in wielding its rule-making powers under Section 5, Paragraph 5, Article 8 of the 1987 Constitution. We are truly proud that this rule is the first ever judiciary-led initiative in the world that specifically caters to the facilitated naturalization of refugees and stateless persons. Through the rule, we can see the Supreme Court's direct involvement in ensuring that the country's obligations under international law are complied with. Its creation is also very timely and relevant today, given the ongoing political and military conflicts around the world, particularly that between Russia and Ukraine. It is our hope that the rule will be able to help and reach those people who want and need it most. Philippine history shows that we have always been at the forefront of welcoming and assisting refugees and stateless persons. It is also worthy to mention that just a few days after the court's approval of the rule, or on February 28, 2022, President Rodrigo Roa Duterte signed Executive Order Number 163, Series of 2022, which institutionalizes access to protection services for these persons of concerns, or POCs. Under Section 5 of that EO, the Interagency Committee on the Protection of Refugees, Stateless Persons, and Asylum Seekers shall continue to coordinate with the judiciary in accordance with the provisions of relevant international laws to ensure that POCs have access to courts and the swift administration of justice. Moreover, we are also aware that there are pending bills before Congress that also seek to improve the plight of refugees and stateless persons. From this, it can be readily gleaned that our country is continuously exerting efforts in fulfilling the pledges it had made during the Global Refugee Forum and high-level segment on statelessness, and in implementing our international commitment of providing protection to POCs. Under Section 3 of the rule, the expedited procedure aims to simplify and reduce legal and procedural hurdles in obtaining Philippine citizenship to facilitate the assimilation and naturalization of refugees and stateless persons into Philippine society. This is with due regard to the fact that these persons, because of their vulnerable circumstances, may not have the complete documentary requirements or sufficient financial means to successfully go through the regular naturalization process under our existing laws. Often, they are the ones who are escaping from conflict and persecution in their home countries. Thus, under Section 9 of the rule, the petitioner's inability to produce certain documentary exhibits shall not be a ground for the denial of the petition if the totality of evidence is sufficient to establish that he or she meets all of the qualifications and does not suffer from any of the disqualifications as provided for in Commonwealth Act number 473. This is further reiterated in Section 20, which states that in resolving the petition, the court shall consider the totality of evidence presented to determine whether the petitioner has all the qualifications and none of the disqualifications specified by law, with due consideration to the petitioner's cooperation throughout the naturalization process. Moreover, under Section 27, the petitioner, unless exempted by law, shall only pay 50% of the prescribed docket and other legal fees. While naturalization is not a right but a privilege, the Supreme Court acknowledges that there are instances that call for a more humane consideration, such as the granting of Philippine citizenship to refugees and stateless persons after they have shown compliance with the requirements under the rule and without, of course, compromising national security. In this regard, while Section 26 provides for the general rule in the proceedings that it shall be confidential, the same provides for an exception, and that is if the court finds that disclosure of any information related to the case is necessary for not security reasons or for other purposes connected to or arising out of the proceedings, the court, upon motion, shall order the release of the necessary information, restricting, however, the purposes for which it shall be used, and only upon the written consent of the petitioner. Another provision that I wish to highlight, and this has been mentioned by the Chief Justice, is that this is the first time that the court is allowing electronic publication. Section 12 of the rule provides that if the court is satisfied that the petition is sufficient in form and substance, it shall direct the clerk of court to cause the publication of the petition, excluding its annexes, for 3 consecutive weeks in the official gazette or its website, and in 1 newspaper of general circulation or its website in the place where the petitioner resides, or the official website of the Supreme Court. These alternative modes of publication aim to reduce the necessary fees and make it less financially burdensome for refugees and stateless persons to apply for naturalization. It also bears noting that at present there are only 5 pending naturalization cases involving refugees. Thus, this special committee envisions that electronic publication can be used as a pilot initiative and can serve as a precedent for other cases that require publication in the future. This is also a step towards the goal of the Supreme Court to have a technology-driven judiciary that is capable of providing equal access to justice in real time. Additionally, the rule allows an unaccompanied child to file a petition for naturalization. Section 5 defines that child as one who is separated from both parents and other relatives and is not being cared for by an adult who, by law or custom, has responsibility to do so. In connection to this, Section 6 of the rule states a petition in behalf of the unaccompanied child or a joint petition involving related unaccompanied children may be filed by the Department of Social Welfare and Development, the appropriate local social welfare and development office where the unaccompanied child resides, or the child caring agency having care and custody of the child. The rationale behind this provision is to comply with the country's obligation under international instruments to ensure the right of every child to acquire a nationality or to ensure that no child is stateless in accordance with the UN Convention of the Rights of the Child. With the courts guided by the best interest of the child principle, the rule aims to afford these children full access to rights, programs, and services that they may otherwise not have on account of being stateless. This provision also creates a safeguard to prevent an unfortunate situation where an unaccompanied child would have to live in limbo and remain stateless until he or she reaches the age of majority. Moreover, it takes into account the global trend of the rising number of unaccompanied refugee children. According to the UNHCR Global Trends in Forced Displacement 2020, approximately 21,000 children applied for asylum in 2020. While to date, there are no unaccompanied refugee or stateless children in our country, the rule considers the distinct possibility that such children may want to seek protection from our country. Between 2006 to 2018, only 8 former refugees were naturalized in the Philippines due to rigid qualifications and lengthy and costly processes. And it is hoped that these special rules will encourage these unaccompanied children to take a look at our country and live here under our beneficence. Through the creation of the specialized rule that expedites the naturalization process, we hope to provide a better life and future to many more refugees and stateless persons by giving them access to a more convenient means of being assimilated and integrated into Philippine society. At this point, may I please request my co-chair in the committee, Justice Joseph Lopez, and the members to please rise and be acknowledged for recognition for the valiant efforts that you and we have all exerted towards the adoption of these special rules. Vice Chair Joseph Lopez, thank you so much. Our members, the Honorable Jose Maidos Marquez, Honorable Maria Josefina G. San Juan Torres of the Regional Trial Court of Morong Rizal, Branch 79. Of course, Dean Sedfrey M. Candelaria, the PhilJet Chief of Office, Research, Publications, and Linkages Office, PhilJet. Attorney Nash Milin A. Marohom Salik, Representative, Office of the Chief Justice. Attorney Jeffrey G. Gallardo, Representative of the Office of Associate Justice Joseph Lopez. I think I should mention this because credit should be given to where it is due. The seeds of this rule actually came from the Gallardo household. Attorney Jeff Gallardo, who before even the creation of this committee had shown to me a draft, a personal draft of the rule. And I'm sure that he was encouraged by his wife, Attorney Ermina, to do this. Both of them had been my students in San Beda College of Law. Also, Attorney Camille Sue May Ting, representative of the Office of Justice Marquez. Also a student, Attorney Maria Melissa Dimson Bautista, PhilJet representative. Attorney Walesa Mercurio, representative of the Public Attorney's Office. Attorney Melvin Suarez, representative of the DOJ, Refugees and Stateless Persons Protection Unit. I'm sure that you have been reporting to Assistant Secretary George Horta, Chief State Counsel, also a student of mine in San Bedalo. Thank you, ASEC Horta. Attorney Dexter Matias, representative of the OSG. Attorney Alexander Bacaro, a former colleague of mine in the DOJ who represents the Community and Family Services International. And of course, the indefatigable committee secretariat, my very own staff, Attorney Helene Rashida Penilla, Ida, thank you so much for everything. Attorney Christine Ray G. Domingo, Office of the Court Administrator, and Ms. Ariel Ann M. Gonzalez, UN High Commissioner for Refugees. Thank you all so very much. Good morning, everyone.
Thank you so much, Justice Hernando. We heard the salient features of the rule and on how it provides affordable and effective means of acquiring Filipino citizenship. It is now time to hear the messages from the various stakeholders. As our valuable partner in ensuring access to justice, I am privileged to present to you Chief State Counsel George O. Ortha II, Head of the Refugees and Stateless Persons Protection Unit of the Department of Justice, to deliver a message on behalf of the Secretary of Justice.
Chief Justice Esmundo, Senior Associate Justice Perlas Bernabe, Associate Justice Leonen, Associate Justice Kagiwa, Associate Justice Hernando, who is also the chairperson of the Special Committee on Facilitated Naturalization for Refugees and Stateless Individuals, Associate Justice Lazaro Javier, Associate Justice Inting, Associate Justice Salameda, Associate Justice Mario Lopez, Associate Justice Garland, Associate Justice Rosario, Associate Justice Joseph Lopez, Associate Justice Dima Ampao, Associate Justice Marquez, and Associate Justice Ko. Chancellor Carandang, Vice Chancellor Del Castillo, Presiding Justices and Executive Judges, Undersecretary Sulit, Executive Directors Fugoso Alcain, Rojas, and Santiago, Commissioner Pimentel Gana, President Coordinator Gonzalez, United Nations High Commissioner for Refugees, Head of its National Office, Valdea Villa Gallardo, ladies and gentlemen, a pleasant morning to all of you. On behalf of the Secretary of Justice, allow me to extend my sincere congratulations to the Supreme Court for its approval, and today, its launch of the rule on facilitated naturalization of refugees and stateless persons. The issuance of the rule is another laudable milestone in our existing refugee and stateless framework, it being the first judiciary-led initiative of its kind at the global arena. This achievement is a testament to the Philippines' steadfast commitment to promote, uphold, and protect the rights of refugees and stateless persons, as it expedites the naturalization to acquire Philippine citizenship. It is truly a step closer in the attainment of durable solutions towards their eventual integration into the Philippine society. Its realization conveys a message to these marginalized and vulnerable persons of concern that they belong. The Philippines has been consistent in opening its doors as a safe haven for refugees and stateless persons. Rooted in the country's long humanitarian tradition and culture of bayanihan, relevant laws and policies were put in place to ensure access by these persons of concern to their basic rights, including protection services of the government. It is significant to note that the rule addresses the challenges when refugees and stateless persons apply for naturalization, such as the lengthy and costly process, by introducing innovations that are protective of their specific and unique vulnerabilities. Indeed, the goal to expedite naturalization proceedings and to reduce as far as possible the charges and costs for such proceedings is envisioned under Articles 34 and 32 of the Refugees and Statelessness Conventions, respectively. Among the salient features of the rule are the following. First, allowance for unaccompanied refugees and stateless children to file petitions for naturalization to ensure that the right of a child to acquire a nationality with the child's best interest is an equally important consideration. Second, the electronic publication of the petition in the official website of this court, with only 50% of the fees to be paid, thereby substantially reducing costs for the petitioners. Third, the relaxation of the financial qualification in harmony with the landmark decision in the case of Republic versus Carbasi. Fourth, the upholding of the principles of non-discrimination, confidentiality, and doing no harm to these persons of concern. Fifth, the expeditious resolution of the petition. With deep gratitude, we recognize the excellent leadership of Chief Justice Alexander Tesmundo and Associate Justice Ramon L. Hernando, and former Chief Justice Diosdado M. Peralta, who spearheaded the creation of the Special Committee on Facilitated Naturalization for Refugees and Stateless Individuals to draft the rule. We are honored to extend our support as a member of the Special Committee through the Department's Refugees and Stateless Persons Protection Unit. This milestone fulfills the country's pledge during the Global Refugee Forum and the high-level segment on statelessness. Specifically, the rule concretized action point number 4 of our National Action Plan to end statelessness by 2024. That is, facilitating the naturalization of refugees and stateless persons. It likewise contributes to the implementation of the strategies outlined in the updated Philippine Development Plan 2017 to 2022 to develop a legal framework for these persons of concern. Similarly, the rule has complemented the recently issued Executive Order number 163, which institutionalizes access to protection services of refugees and stateless persons and asylum seekers in the country. It promotes the right to nationality as an enabling right. It shows our collective vision for a society that empowers and improves the lives of refugees and stateless persons. We are confident that the rule will serve as a guiding legal framework in building a better future for our refugees and stateless persons. Looking forward, the Department of Justice will always be one with the judiciary in ensuring access to justice and protection of these persons of concern. Thank you very much.
Maraming salamat, Chief State Counsel Ortha. the Department of Justice Refugees and Stateless Persons Protection Unit, created pursuant to Department Circular Number 58, is mandated to facilitate the identification, determination, and protection of refugees and stateless persons in coordination with the relevant stakeholders. Additionally, the Secretary of Justice is the chairperson of the Interagency Committee on Protection of Refugees, Stateless Persons, and Asylum Seekers of the newly enacted Executive Order Number 163, institutionalizing access to protection for services, refugees, stateless persons, and asylum seekers. Our next keynote speaker is a resident coordinator of the United Nations in the Philippines, Mr. Gustavo Gonzalez. Mr. Gonzalez, as the UN Philippines resident and humanitarian coordinator, brings more than 25 years of extensive managerial and leadership experience in development, humanitarian affairs, and peace building, performing for several UN entities such as the Food and Agriculture Organization, United Nations Development Program, and International Organization for Migration across 3 continents, Central America, Africa, and Middle East. He has also served in various peace building and reconstruction programs in Guinea-Bissau, Central African Republic, Angola, Liberia, Mozambique, and Nicaragua. Ladies and gentlemen, Mr. Gonzalez.
Thank you very much. Chief Justice Gesmundo, Associate Justice of the Supreme Court, Associate Justice Hernando, Chancellor Carandang, and Vice Chancellor del Castillo, our esteemed presiding justice and judges, Chief State Counsel Horta, Undersecretary Sulit, Executive Directors Furgoso Alcain, Rojas, and Santiago, President Pimentel Gana, Head of National Office, my dear colleague Valdivia Gallardo, and to all our distinguished guests attending physically and virtually, a pleasant morning. I think that today is in some way a historic moment, historic step forward to human rights. And as the representative of the United Nations in the Philippines, I very much appreciate having the opportunity to participate at the launch of the rule on facilitated naturalization of refugees and stateless persons. As I said, this is a remarkable milestone in the protection and on the human rights agenda of the Philippines, as it represents the first judiciary-led framework that expedites the naturalization procedure. And this is in some way a contribution to the United Nations joint program that we have just signed with the government within the context of the Human Rights Council Resolution 4233. And this achievement has been possible to the leadership of Chief Justice Gesmundo, Associate Justice Hernando, and as I was mentioned, former Chief Justice Peralta. I recognize the members of the Special Committee on Facilitated Naturalization for Refugees and Stateless Individuals who have tirelessly worked towards the finalization and approval of the rule. As we see, the rule addresses the challenges, and it was mentioned by the previous speakers, challenges faced by refugees and stateless persons in applying for Philippine citizenship. It takes into consideration their specific and unique circumstances. By allowing unaccompanied children to apply for naturalization, it fulfills the state's obligation under the UN Convention on the Rights of the Child. These persons of concern no longer need to wait for years before they can become Filipinos through its expedited procedure. And I think that this is extremely important in a context where this world, is severely affected by the forced displacement of people as a result of the climate crisis, and as we see, as a result of war. The rule serves as a manifestation of the Philippines' commitment to the advancement of human rights, especially the right to a nationality. Bravo. This right is integral in accessing other rights. This is even more important within the context of the pandemic, as it does not discriminate no one on status or nationality. By providing means to make the acquisition of Philippine citizenship more accessible to refugees and stateless persons, the rule contributes to the collective vision of the Agenda 2030 on the Sustainable Development Goals, and particularly on the principle to leave no one behind. It is particularly oriented toward the achievement, as I mentioned, of the Sustainable Development Goals 16 on ensuring inclusive societies for sustainable development and providing access to justice to all. And this is in line with target 16.9 on the SDGs that mentions providing legal identity for all, which includes citizenship. The UN in the Philippines remains committed to continue its partnership with the Philippine government, including with the judiciary, through its UN Socioeconomic and Peace-Building Framework for COVID-19 recovery. As you know, this is the main cooperation framework that we have with the government, and it was just revised and updated, taking into account the challenges of the COVID-19 pandemic. Under this framework, the United Nations is committed to uphold the rights of the people it serves and protects by addressing inequality among vulnerable and marginalized populations, including refugees and stateless persons. The socioeconomic and peace-building framework of the United Nations has a goal on social cohesion that aligns with efforts to provide opportunities for refugees and stateless persons to locally integrate and contribute to their communities. And naturalization is one step closer towards the realization of that goal. Rest assured of the support of the United Nations, particularly from our sister agency, UNHCR. We will continue this support to the Philippine governments, including the judiciary, in ensuring a dignified and protected environment for refugees and stateless persons. Thank you so much, and congratulations once again.
Thank you, Mr. Gonzalez. The next speaker who will deliver a keynote message is Attorney Maria Hermina Valdeavilla Gallardo. Attorney Gallardo is the head of the Philippines Office of the United Nations High Commissioner for Refugees, or UNHCR. With more than a decade's worth of experience, Attorney Gallardo has contributed to the operations efforts to enhance the protection space for the forcibly displaced and stateless persons through policy and legal development advocacy and stakeholder engagement by providing technical and practical knowledge to duty bearers. Ladies and gentlemen, please welcome Attorney Valdeavilla Gallardo.
Chief Justice Gesmundo, to the Associate Justices of the Supreme Court, Chancellor Carandang and Vice Chancellor Del Castillo, to our esteemed presiding justices and presiding and executive judges, Chief State Counsel Ortha, Executive Directors Fugoso Alcain, Rojas, and Santiago, President Pimentel Gana, Resident Coordinator Gonzalez, our distinguished guests, good morning. I offer my heartfelt congratulations as today marks an important milestone in history. The Philippines launches the first ever judiciary-led rule on facilitated naturalization of refugees and stateless persons. The rule comes at an opportune time when refugees and stateless persons need it the most in the midst of crisis and amid the challenges of the pandemic. These persons are in limbo. They are often forgotten and they are often left behind. So they look to the Philippines for solutions. Hailed as a global leader on refugee and statelessness protection, the Philippines has generously welcomed the vulnerable and marginalized with open arms. Truly, it is aligned with the spirit of malasakit. This is the place where refugees and stateless persons can truly belong and call their home. However, becoming a refugee or stateless person is not an end in itself. After all, being forcibly displaced or being someone without a nationality is never a choice. It is beyond their choice, but brought about by unfortunate circumstances. Guided by the state's obligations under the 1951 Refugee and the 1954 Statelessness Conventions, the rule recognizes this. It provides the means by which these persons of concern can acquire durable solutions through the acquisition of a citizenship. In doing so, it envisions a future where they can fully enjoy and access their full rights as Filipinos, allowing them to fully integrate with the economic, social, and cultural life of the Philippines. We are happy that this rule addresses the conundrums faced by our people of concern. As mentioned a while ago, between 2006 to 2018, only 8 former refugees were naturalized. And such process usually spanned for years and even more than a decade. But now with this rule, they only have to wait for a decision in about 90 days, if unappealed. As mentioned a while ago, costs also are prohibitive. The costs discourage persons of concern to apply or continue their naturalization petition. And the rule acknowledges this problem. It solves this through a welcomed innovation of electronic publication. Fees are either reduced or waived. And UNHCR considers this as an important humanitarian gesture and gives a fair playing field for people of concern. These requirements, which are aligned with the Carbasi ruling and other frameworks, have been liberalized considering the circumstances. We are also happy that this rule is very much inclusive and non-discriminatory, placing great importance of ensuring equally accessible, durable solutions for refugees and stateless persons, regardless of their race, their gender, their ethnicity, their country of origin. This includes unaccompanied refugees and stateless children in order to fulfill their right to nationality. It is also interesting to note that change of name is an option under the rule, which thereby gives people of concern an opportunity to share their roots and rebuild their lives. Apart from the 1951 Refugee and 1954 Statelessness Conventions, the rule fulfills the 2019 Global Refugee Forum and high-level statelessness segment pledges to enhance the policy, legal, and operational frameworks for refugees and stateless persons, including their facilitated naturalization. It perfectly aligns with the objective of the 1961 Statelessness Convention, of which the Philippines recently acceded to reduce statelessness. It upholds the right to nationality under international law. We hope that the unwavering commitment of the Philippines through this and other efforts could also encourage other states who are hosting refugees and stateless people to follow suit. Of course, all of this would not be possible without the steadfast leadership of our beloved Chief Justice Mundo and Associate Justice Hernando, my professor. We also extend our warm appreciation to former Chief Justice Peralta for the creation of the Special Committee on Facilitated Naturalization for Refugees and Stateless Individuals. This establishment of the committee served as an impetus to pursue a feat that has never been done before. Let me also express my sincere gratitude for the opportunity given to UNHCR to support the special committee. Of course, it is a privilege to be in the midst of dedicated experts who care for our refugees and stateless persons. I personally witnessed the dedication and expertise of all the members since 2018 when I was still the head of protection unit for UNHCR. At the heart and center of our collective work, of course, are our people of concern. It is hoped that this rule gives them a chance to start again and live a life with dignity and security. This goal could only be achieved if we continue to work together to bring about more positive change and echo the voices of the most vulnerable groups through our rules, through our policies, through our laws. We owe it to every person, child, and family who seek a secure place where they can develop to their full extent and capacity, and to which Philippines could be called their home. In closing, UNHCR Philippines is committed to continue its collaboration with the judiciary in protecting and safeguarding the rights of our people of concern and achieving sustainable solutions for them. Magandang umaga po. Salamat.
Maraming salamat, Attorney Gallardo, in this process. to formally present to the court the publication of the Rule on Facilitated Naturalization of Refugees and Stateless Persons prepared by the Philippine Judicial Academy or the PhilJA. May I call on the Chief Justice, Chief Justice Gismundo, Justice Hernando, the Chairperson and the Special Committee on Facilitated Naturalization for Refugees and Stateless Individuals. I would also like to request your presence on the floor again to our development partner, UN Resident Coordinator, Mr. Gonzalez, and to Attorney Gallardo, please. Lastly, I would like to call on the PhilJA Chancellor, Chancellor Rosemary Carandang. The PhilJA is our partner who provided support for the cover design and printing of this publication. Incidentally, we have good news. The rule, which is in electronic publication or EPUB format, is already in the Supreme Court website and is ready for viewing. May we request Chief Justice Gismundo, Justice Hernando, Mr. Gonzalez, Attorney Gallardo, and Justice Carandang on the floor, please. Thank you. I also request Justice Lopez, Vice Chairperson, to join us here on stage. Chancellor Carandang will be presenting a copy of the published rules to Chief Justice Gismundo. Thank you so much, Chief Justice, Justice Hernando, Chancellor Carandang, Justice Lopez, Mr. Gonzalez, and Attorney Gallardo. We wish to express our appreciation once again to the United Nations High Commissioner for Refugees for their support for the drafting of this rule. Before we end this ceremony, we wish to thank everybody who made this media launch possible, starting with the member offices of the organizing group, the Office of the Chief Justice, Office of the Court Administrator, the Public Information Office, the Program Management Office, the Management Information Systems Office, the Philippine Judicial Academy, and the offices that provided tremendous support to us, the Supreme Court Fiscal Management and Budget Office, and the printing services through the Office of Administrative Services. We would also like to share with you that Chief Justice Gismundo himself has initiated the move to launch the new rules in order to give it the necessary visibility and to generate awareness among its stakeholders. Again, we would like to thank our development partners and our government partners, the United Nations High Commissioner for Refugees, the Department of Justice, the Office of the Solicitor General, and Community and Family Services International for their continuous cooperation and support to the reform initiatives of the judiciary. Our program will end with the Philippine Judiciary hymn, but afterwards there will be a photo session, which we will direct. May I invite everyone to join the singing now of the Philippine Judiciary hymn. Kindly stand.
Was born of liberty.
and gentlemen, you may be seated. To recall this occasion for posterity, we will have a photo session. There will be three main characters in the photo session: the Chief Justice, Associate Justice Hernando, and Justice Lopez, please. And then I will call on each group who will join the three on stage. May I request the ushers to be on standby, please. Thank you. So for the first round, we will request the members of the court who are present here today to kindly join the Chief Justice and Associate Justices on stage, please. The Associate Justices, please. Justice Kadiwa, Justice Ko, and Justice Dimaampaw. Thank you, Your Honors. Now may I call on, thank you, Your Honors. Thank you po, Chief Associate Justice Lopez and Justice Hernando, please stay on stage po. Sorry, kayo po yung main characters. Ushers, may I call on now the Philja Chancellor and Vice Chancellor to please join our Honorable Chief Justice and Associate Justices on stage. Wala po si Vice. Okay po. Thank you. Justice Karandang. Please be on standby, executive judges who are here. Thank you, Chancellor Karandang. May I now call on the executive judges to please join our associate justices and the Chief Justice. So are the executive judges virtual? Okay, please just take a screenshot on your screen. Ay, meron pong isa. Hello, ma'am. Hello, Judge. Please be on standby. Our national government agency partners, UNHCR and the United Nations Resident Coordinator. Thank you, Jay, and our development partners, please. Thank you. All the national government agencies and agencies represented, please. Thank you. Ushers, please. Please be on standby, members of the Secretariat and the committee and Chief State Counsel Ortha again. Thank you to our development partners. Asan na yung committee? Please join us on stage. Moment nyo to. Chief State Counsel Ortha, stay. To everyone who graced this event here at the Supreme Court and Banc Session Hall and virtually through the live stream. Thank you very much and a pleasant day to all. Stay safe and take care. Mabuhay!